I wanted to add real quick a fifth video to the series here having to do with discovery. All four of my charges are misdemeanor, and because of that fact, the prosecution is stating that I'm not entitled to discovery. In fact, Isabella County Prosecutor Risa Scully is citing Michigan Supreme Court administrative orders as the reason she can deny discovery to me, trying to defend myself against misdemeanor charges. What the state's trying to do here is draw a real line, a real distinction between misdemeanor crimes and felony crimes, and they're trying to take away people's ability to request or demand discovery if they're only charged with misdemeanor crimes. I think it's really important to point out at this time that the penalties for these four misdemeanor crimes that I'm trying to defend myself against include close to almost 2 years in jail. For security alone, that's 12 months. So, you know, it's extremely important that every defendant in the state of Michigan, and in every state for that matter, is allowed to put up a defense. So Risa Scully quotes Administrative Order number 1993-3. This was wrongly cited. It doesn't really exist. It was actually rescinded by a different administrative order. She also cites Administrative Order 1999-3. Again, these are Michigan Supreme Court administrative orders. These are not acts of the legislature. Discovery in misdemeanor cases. On order of the court, in case of People v. Sheldon, 234, Mich. App. 68, etc., etc., the Court of Appeals ruled that MCR 6.201, which provides for discovery in criminal felony cases, also applies to criminal misdemeanor cases. That rule was premised on an erroneous interpretation of our administrative order, and this is why we don't use administrative orders, because they're not written like laws. They're basically very vague opinions of the Michigan Supreme Court, based on an erroneous interpretation of our administrative order 1994-10. By virtue of this administrative order, we wish to inform the bench and the bar, not the people of the state of Michigan, that MCR 6.201 applies only to criminal felony cases. Okay, now if you look up MCR 6.201, you will find that the words misdemeanor and felony do not appear anywhere in that particular court rule. In fact, it just talks about discovery and criminal cases, and both misdemeanor and felonies are criminal cases. So these different distinctions between misdemeanor and felony are very dangerous to we the people because they're trying to take away our ability to defend ourselves in these misdemeanor cases. Well, you know, if you can lose 2 years of your life in jail or a year and a half of your life in jail when they stack this stuff up on you, even though it's misdemeanor, you have to be able to have discovery. Here's an excerpt from the court case People v. Sheldon. This is an excerpt. Administrative Order number 1994-10 makes no distinction between felony and misdemeanor cases. Instead, it states in straightforward language that MCR 6.201 governs discovery in criminal cases heard in the courts of the state. Now, in criminal cases heard in the courts of this state, there's no differentiation there between misdemeanor and felony. We read this clear language to include misdemeanor cases as well as felony cases. So the allegation is up here that they're talking about one or the other are just not true in the administrative order cited by Risa Scully, which again is not legislation, and that number is 1999-3. It goes on to say, because the court rules nowhere expressively state that MCR 6.201 does not apply in misdemeanor cases or that it applies only in felony cases. There is no direct conflict between the court rules and the administrative order cited as 1994-10. Okay, 1994-10, and this is really important. Again, it's not legislation. On May 4th, 1994, the governor signed House Bill 4227 concerning discovery by the prosecution of certain information known to the defendant in a criminal case. Okay, now what we're talking about here is reverse discovery. This is where the prosecution is trying to discover things that the defendant knows, not things that the prosecution knows that the defendant wants to know, but just the opposite. The prosecution is looking for discovery from the defendant. Okay, that's all this administrative order is addressing. I'm going to read it again here real quick. Concerning discovery by the prosecution of certain information known to the defendant in a criminal case. 1994 PA 113, blah, 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 blah. On November 16th, 1994, this court promulgated Michigan Court Rule 6.201, which is a comprehensive treatment of the subject of discovery in criminal cases. Again, just criminal cases. There is no distinction with regard to discovery as it applies to felony cases or misdemeanor cases. Simply criminal cases. On order of the court effective January 1st, 1995, discovery in criminal cases heard in the courts of the state is governed by Michigan Court Rule 6.201. Again, discovery in criminal cases, not misdemeanor or felony, heard in the courts of the state is governed by MCR 6.201. And this is really important. I was just denied discovery based on these court rules. And I'm going to put up another picture of this page that I've created here that has the administrative orders from the Michigan Supreme Court. It has the excerpt from the case that they're quoting and talking about in here. And I'd like you folks to fact check everything that I do. Nothing I do is I don't ever ask anybody to just accept the things that I'm talking about here, but look them up. On here there's Administrative Order 1993-3, 1999-3, 1994-10, and the case site from People v. Sheldon. It's a Court of Appeals case, and do the research yourself. Any criminal cannot be allowed to be denied discovery. I mean, it's just as bad as denying a defendant in an eviction proceeding due process. Deny standing, deny due process, and essentially create an eviction proceeding that is ex parte, even though all parties are present. So ex parte means one side. Anyways, I just wanted to get this out. This is hugely important, and this is part of what's going on in our judiciary here in Michigan, and this stuff's got to stop. We got to stop allowing this stuff, and we got to push forward and know that if you find yourself defending yourself against any misdemeanor crime, you're going to run into static getting discovery, which is going to prevent and prohibit you from putting up an adequate defense, which may lead to your conviction. So with these things in mind, it's critically important that you pay attention to what we're trying to do here. Okay, this isn't me blowing my own horn. This isn't anything like that. It's chipping away at the rights of the people to finance the state, to finance their own oppression. Because when these things are allowed to happen, we the people are going to lose, and we got to stop losing, folks. We're losing ground left and right here, and this is just one of the ways. Please fact check me, and if you find any errors, be sure and let me know. Thanks.